is a community education production brought to you by the Bar Association of Montgomery County and the Montgomery County, Maryland Bar Foundation. The program is designed to provide you with general information regarding your rights and obligations under the law. It is not intended as specific legal advice. You should discuss the facts and circumstances of any particular matter with your own attorney and obtain advice specific to your case. The participants are local attorneys who have volunteered their time to bring you this program. We hope you find it informative and beneficial.
Welcome to Law School for the Public. My name is Laurie Cleary, and I'm a partner in the Bethesda law firm of Lurch, Early and Brewer Chartered. Most of us are aware that the courts may issue restraining orders that stop one person or entity from causing injury of any kind to another. With respect to orders designed to address threats of harm to individuals, Maryland courts can issue two types of restraining orders: peace orders and protective orders. Both are issued through a civil proceeding in court, but the violation of either type of order can result in a criminal conviction. To help us understand how and when these orders may be issued and what they accomplish, we are fortunate to have with us two guests who deal with them every day. The Honorable Barry A. Hamilton has served as a judge of the District Court of Maryland for Montgomery County since 1996. Prior to his appointment to the bench, Judge Hamilton served as an assistant state's attorney here in Montgomery County for 20 years. Both as a prosecutor and as a judge of the district court, Judge Hamilton also served for 10 years as a member of the state's Family Violence Council. Chief Deputy Darren M. Popkin has served as second in command at the Montgomery County Sheriff's Office for the past 10 years. Prior to that time, Chief Deputy Popkin served the county as a deputy sheriff for 14 years. Chief Deputy Popkin also served on the committee that designed and implemented the county's new Family Justice Center, which formally opened in May of this year. The Justice Center provides one-stop services to victims of domestic violence. Judge Hamilton and Chief Deputy Popkin, welcome to both of you.
Thank you very much. It's an honor to be here.
Glad to be here.
Thank you. Judge Hamilton, how much of the docket of cases before you every day involves either the issuance or the modification of a peace or protective order?
Okay. 2 of the 11 judges of our court are assigned to handle the peace orders or protective orders basically on a half-day basis. So that's 5 days a week in both the courthouse in Rockville and in Silver Spring.
And you may be asked to issue these for the first time or to modify an order that you previously issued?
That's correct.
Okay. And Chief Deputy, how does your work in the Sheriff's Office involve you in the process for peace and protective orders?
The Sheriff's Office in Montgomery County, amongst many law enforcement duties, is also responsible for the service, the maintenance, the archiving of all the peace orders and protective orders that are issued in Montgomery County and that are also sent to Montgomery County from other jurisdictions throughout the state as well as throughout the country.
And when you say service, that's actually serving the order on the person being restrained?
That would actually be serving the order on the person who the order is directed to be served to. That's correct.
I see. Judge, let's begin by defining some of the terms that are involved in peace and protective orders. First of all, what are restraining orders as they're generally known, and in particular, what are peace and protective orders?
Sure. Protective orders are those which are issued or can be issued when there's a certain relationship between the parties. We call the parties in both kinds of cases petitioner, that's the one who's asking for the relief, and respondent, the person against whom the relief is being sought. So to get a protective order, there has to be some kind of relationship, either familial or marital, between the parties. They can be current spouses, ex-spouses, parents, children, relatives, even in-laws. Plus, they can be cohabitants if they've lived together for within 90 days within the previous year.
I see. And individuals who haven't been married to each other but who have a child together, do they have?
And if they have a child in common, that's another category that makes them eligible for a protective order. Peace orders cover everybody else.
Okay. So if I have a gripe with my coworker who I think is harassing me, that would be the peace order situation.
Your coworker, your neighbor, whomever is somebody you're not related to, yes.
I see. Okay. There are other restraining orders that are issued in criminal court or in connection with criminal proceedings,
Sure.
aren't there?
Yes, if typically if a person is charged with an assaultive crime, the commissioner or judge can make a condition of their bond no contact with the person of the complaining witness.
I see. And I think we've all heard of other kinds of temporary restraining orders and injunctions and things of that nature, but those really aren't what we're talking about
Right.
today. Chief Deputy, in the situations that we are talking about today, who are the petitioners and how does your office become involved with them before a peace order or a protective order is issued?
Historically, the people who come in to seek protection in these restraining orders, protective orders, or peace orders, historically would go to the courts first. And once the judges heard the cases, they would actually then once the order was actually issued, they would then come to the sheriff's office with their orders. And then the sheriff's office, as I said, was responsible for the actual service of these orders, going out and finding the respondents in these cases and actually servicing the orders. But now, because there's a change in the way we've been doing business with the opening of the Family Justice Center, often now we are actually seeing these victims in these domestic violence cases prior to them actually going to court.
Oh, I see. And how does the process start? Judge, does a circuit or district court judge such as yourself have to issue these orders, or can something be put in place before an individual goes to court?
It can be either way. A citizen can, during regular business hours, either go to the district court or to the circuit court, it doesn't matter, and fill out an application for a peace or protective order. During non-business hours, after 4:30 and on weekends, they can also obtain what's called an interim order from a district court commissioner who are on duty 24 hours throughout the county. And the commissioners can't give quite the extensive relief that a judge can, but they can cover the gap until that person can come back to court and then get a temporary order.
That wasn't always the case in the county, was it?
No, the institution of having the commissioner be able to issue interim orders is only a few years old. Before that, if you got to the courthouse too late and it was a Friday, you had no opportunity for relief, at least in terms of a peace or protective order, until Monday morning.
Okay.
Yeah, that was a great step forward for the victims of domestic violence, because it used to be that Friday afternoon when courts closed, they weren't eligible to receive those sort of orders until Monday when the courts opened again. And now we have protection for them by going to the commissioners over the weekend hours, where the sheriff's deputies will actually go to the commissioners, get those orders, and then serve them as well over the weekends or on the midnight time when the courts are closed.
I see.